So this panel is about, as you all know, of abuse of dominant or monopolization in the US in digital markets. So it's a very hot topic, I guess. Well, I'm Juan Pablo Iglesias from SECO. And first of all, let me introduce the panelists with whom I have the privilege to be sitting today with. And I will go in alphabetical order. So first we have Mimansa Bairathi. She is currently an assistant professor of marketing at the University College London, UCL, and she specializes in information design for digital platforms markets. And she holds a PhD in quantitative marketing. That's right, right, yes. Mimasa? Perfect. And from London Business School, and her work has been published in leading journals such as Marketing Science. Then we have Michael Lawrence, who also came last year. So nice. Thank you, Michael, for coming this year as well. He is a lawyer from Georgetown University and Bachelor of Political Science from the University of California, LA. He currently serves as Senior Competition Counsel at Google, where he advises on issues of competition and intellectual property. And previously, he worked as an antitrust attorney at Intel Company, and as an associate at Latham Watkins. He is also vice chair of the Media and Technology Committee of the American Bar Association. And finally, we have Carlos Patron. He is an abogado from the university, lawyer or abogado for Spanish speaker of the Universidad Católica del Perú. He has an LLM of the Yale University and a Master of Science in Public Policy for Latin America of the University of Oxford. He's actually a partner of PPU, the law firm, where he specializes in antitrust law and regulated markets. He is also a professor at the Universidad Católica del Perú and the Peruvian University of Applied Science. So thank you all three for being here today. And sadly, Domingo Valdez, who was also a speaker of this panel, who won't be able to make it because he has some personal issues. But he's okay. So don't worry. Yes. So let me start. We have a lot of questions and different topics. And before going to abuse of dominance, let me make some questions from a broader perspective. And of course, an unavoidable question for these kinds of panels is the DMA, right? The Digital Markets Act of the European Union. We don't have no one from Europe in this panel. So what I want to ask is how the DMA, it has any impact in your respective countries, whether in the competition agencies, enforcement actions, or maybe in just the corporate behavior of the companies. So, of course, let me start with your opinion, Michael, on these issues. So, the influence of the DMA in the US.
Thank you very much. And my comments are my own only and not necessarily those of Google. So in answer to the question of what's the effect of the DMA been on the US, I would say there's a yes and no to this. There has been an impact of the DMA on US companies who are doing business in Europe. And the impact is just like any other European company in that we have to make changes. And some of the changes are quite painful. So for example, in the case of Google, one of the changes we have to make, and for those who use Google, you'll know that if you say do a search and say it's a business, there'll be a map on the search results page. You could normally click through to that map in order to see it expanded. Under the DMA, because of the platform rules, we had to make a change where there's I'll call it a thumbnail of a map, but you can't click through. In order to get to maps, because it was viewed as preferencing Google Maps from search, you have to then go to Google Maps separately. And there have been user complaints. In fact, users thought that Google had broken. And we were like, something else happened, which is that we had to make a product change. Another example of an impact relates to flights and hotels. Google has a feature where if you want to search for, say, the best hotel, or prices of hotels, it used to be that we could run this service, and we had it in Europe, and we can no longer do that. And it had to be modified. And one of the things that we had to do was, because it was viewed as competing with online travel agencies, we have to make room for them in our results. And as a result, hotels in particular complained that their direct bookings that they had gotten from Google, because we don't charge for this, when the user wanted to, say, make a booking, they'd go directly to the hotel from the Google search page. Now they have more space for these online travel agencies. Direct bookings at hotels had dropped 30%. And the hotel industry complained to the commission that now they were losing this direct traffic, and so users were now paying more because they would have to pay the online travel agencies, which charge a commission. And we've raised these issues with the commission. The DMA says what it says, and that'll be worked out, with the commission. But I do think that the impact has been real on U.S. companies. Now, in terms of the United States, within the U.S., I don't think that the Trump administration, I know we'll talk about this more, I don't think the U.S. internally has seen a change because of the DMA. We still have the same law, our Sherman Act, which is our antitrust law, our main antitrust law. There are more than that. The case law and the courts still continue to apply it. We'll talk about this more, but the investigations against tech firms continue. And so I think that the impact has been very different in and outside of the US. And I would say, while there's certainly differences of opinion, I would say most people in the United States would say that the antitrust laws are sufficient, that they don't feel the need to adopt a platform, an ex-ante platform regulation like the DMA.
Okay, thank you, Michael. And so let's go with you, Mimasa. What is your opinion in this?
Yeah, I'd like to take a step back because I think I'm the closest geographically to Europe in this panel. And I think I agree with the broad points that Michael made about the effects of DMA, but I think it's kind of important to also understand how Europe thinks about specific harm posed by these digital platforms relative to how US has traditionally thought about it. And even though the intention of regulators, whether it's in Europe or in the US, even though the aims are similar, which is to promote competition and reduce consumer harm, the way they go about it philosophically, it's been very different, as we've seen now. So if we focus on the case of the EU and specifically DMA, DMA is kind of the way the regulation, the law has been drafted. It's more proactive in its approach. Like Michael said, it's kind of ex-ante regulation. So what it does, it recognizes some large platforms, which it considers already has a very large market share, and hence in some way designates them as gatekeepers. So these are basically 6 platforms, the GAFAM companies and TikTok. And the idea is the law in some way understands that these companies hold a lot of monopoly power in these respective sectors, and then it tries to come up with systematic interventions to ex post unwind some of this power. So in essence, what it does is it recognizes that certain actions are actually harmful to begin with, such as foreclosing rivals, not giving interoperability of data, or the power that emerges from having a lot of data. And so essentially the idea is it basically sets forth certain rules via which platforms are supposed to operate in the EU. So in essence, they should not be self-preferencing their own products. There needs to be data interoperability. They should not be abusing the data that they have access to. And that's where one of the changes Google actually made in Europe, which is essentially those maps are no longer clickable in the search results, that's a result of DMA be asking Google not to self-preference its own product, which is the map. Now, US takes a very different approach to it. So US approach is more ex post. You have to demonstrate specific harm in the form of, say, rise in prices or specific consumer harm, and quantify it to actually say that this particular company is not operating by the laws, be it the Sherman Act. And so in some way, I would say more generally, because the focus of DMA has been these large tech firms, these 6 large tech firms, 5 of which are American, and for all we know, the 6th might end up being American as well. It's impacted American firms, but I'm not really sure if it's really impacted US as an economy insofar as it interacts with digital platforms to a large extent, if at all. But my personal opinion has been that given this, this market of digital platforms, which has undergone the kind of market failures that we witnessed in the past, we've allowed these platforms to actually become very large. And in some way, they have a lot of power in monopolizing what we see and what we get access to. I think an ex-ante regulation might not really be the worst idea to begin with. Of course, even though we say it's ex-ante, the idea is ex-post, we want to reduce their power. And how successful it's going to be in doing that, that remains to be seen.
Okay, thank you, Mimasa. Mimasa, a very interesting point of view. And let's go to Latin America, Carlos. At least in Chile, we don't have a project or a build of law similar to the DMA. I know that in Peru, you don't have it as well, but has the DMA produced any kind of impact at the competition agency level or the Congress or, I don't know, people in general?
Okay, before switching to English to facilitate the conversation, let me just thank Felipe, muchas gracias, Dani, y los organizadores del evento por invitarme acá. Okay, short answer, no. Long answer. It's inevitable that these types of theoretical, premises and theories that respond in Europe will eventually reach our shores. They always do, right? We saw it a couple of decades ago when hub and spoke was the big thing. We saw it pre-pandemic and during the pandemic with a lot of labor-related antitrust issues and non-poaching and so forth. And sooner or later, these topics of DMA, they've already caught the authorities' attention, and they'll see how they gradually bring some elements of this into their analysis. Now, and this is speaking strictly from my experience in Peru. I don't know if this is applicable to other Latin American jurisdictions, but if you ask me, should Latin America have similar DMA policies? My answer is no. I mean, and it's based basically on two things. First of all, I'm not a friend of, First of all, I'm not a friend of ex-ante control regimes. And I want to touch on something that was said in the previous panel. I think that inevitably, and sorry, my notes are in Spanish and now I have to speak in English. It will be inevitable that these types of controls will lead to lower innovation and lower creativity. They will tend to asphyxiate, suffocate creativity, innovation. Who's going to invest in better consumer experiences if later I can't click on the map? I mean, it makes no sense to keep on innovating and trying to improve consumer experiences. The risk of false positives, I'd rather have the risk of a harm to the market that can be later sanctioned and corrected, exposed, than the risk of false positives, because we really don't know what we're losing out on when we have false positives due to these types of ex-ante regulations. But far from that, which is, I know is theoretical and even political, I think that Latin American agencies have a whole different set of problems to prioritize, right? We're far away from European Commission standards or FTC or DOJ standards. We have institutional problems we have to address. We're still underfunded. We still have limited human resources and financial resources, and we still have to work very hard on these topics. And we still have to work very hard on developing a competition culture in our countries, right? We've seen it. We've seen it in Chile. We've seen it in Peru. Chile has made significant progress, but we see it among the entrepreneur class. There's not really a solidified competition culture in our countries, and we have to keep on working on doing this. And there's still a lot of work in traditional brick and mortar economic sectors, in healthcare and transport and logistics and distribution. In Peru, 70% of distribution is still traditional. And I'm not even talking about modern retail, I'm talking about like traditional markets. So if we're distributing 70% of our products through traditional markets, why are we even discussing Amazon? We have a whole lot of problems that we have to address first, before that, and I think that's what our Latin American authorities should try to prioritize, at least in the short run.
Okay, thank you.
If I could,
Thank you, Carlos. Yes, please. Go ahead.
yeah, I would add, I, with all due respect, I have a different view. I understand the objectives and goals of having ex-ante platform regulation. There's a concern that tech companies are large and that their impact could be widely felt. I think there's also a thought that markets move fast, and so this is a way to address things. One thing I don't think that's well understood is the actual requirements that I think would be needed to invest in the agency itself to fund it. I know I've done and others have done, tried to figure out how large the agencies have gotten, like how many people has the EC hired, and it's potentially in the hundreds or even low thousands. And if you're going to have to make that kind of commitment for just the DMA, why not put the resources into doing better ex post investigations? Obviously, that's not my call. That's with the European Commission and Europeans to decide. But I don't think it's maybe as well understood that there's an enormous cost, that if you create these rules, you own it, because you're going to otherwise potentially paralyze the companies who have to comply. And if you're getting questions or complaints from the outside who says, I think they're violating your rules in your country, and then you're the company trying to comply and trying to get the attention of the authorities about how are they interpreting their own rules, if you don't have the resources, you're going to have a bottleneck, and then those companies are going to say, I don't know how to comply with your laws.
Yes. Well, we will see how it goes. Many Latin American countries are somehow importing the artificial intelligence law from the European Union, but they haven't done so with the DMA. So we will be really aware of what happens in Congress and state regulators with that. But let me move forward to the second part, and you, Michael, somehow already said something about it, which is just as the DMA is an unavoidable topic, also is the current president of the U.S. But don't worry, I just will keep this restricted to competition law. But I just want to ask you, what do you think will be, or it is now actually, the approach of this administration to the digital markets or digital regulation, aside from the DMA?
Yeah, I would say the Trump administration opposes a DMA-like approach. They obviously, it's not one person, but the signs point to the fact that the Trump administration's view of antitrust is that when it comes to platform regulations, that's not the right approach. It's too rigid, and that we should have a fact-specific approach. And so I don't think we're going to see the administration pushing for a platform regulation. That said, it doesn't mean that the Trump administration is not coming after tech. There were a number of cases against Google that was filed under the first Trump administration. There's a Meta investigation, there's Amazon investigation, there's an Apple investigation. There are news reports that there's now this started under Biden, but an NVIDIA investigation. And so, for those who don't know, NVIDIA makes many of the chips that power, they're called GPUs, graphic processing units. They power AI in data centers. And so you have, I think, full steam ahead with the Trump administration with these cases that were filed either under the first Trump administration or Biden administration. And I don't see any sort of change in the direction of the administration. And so I would say, as far as we can tell, in many ways it looks like a traditional conservative administration, but it is nonetheless, vigorous antitrust enforcement.
Okay, I understand. Mimans, I don't know if you want to say something about the current administration in the U.S.?
I mean, I could briefly talk about, so first and foremost, I don't think we know enough at this point of time. It's still early days, and what I'm going to say is purely speculative. But I think if we go by the rhetoric of the current administration, where they've basically, I agree with Michael in the fact that we are not looking perhaps at a DMA style regulation being brought into place, but because the Trump administration the White House has made noises about and even threatened the EU about the burdensome acts in the DMA, which actually is placed on US tech firms because of the DMA in Europe, to the extent that they've also threatened tariffs to the European Union if the EU comes aggressively after these big tech firms under the DMA. So I don't think they're certainly looking at something like a DMA, but I feel like it's probably going to be a more case basis kind of an approach, potentially. And there was an executive order from the Biden-Harris era, which I think has been recently revoked by the Trump administration. It looked at aggressive antitrust scrutiny more broadly, which also includes tech firms. So if I were to draw any signals from them, that I would probably say they might take a bit less aggressive of a stance, but it still remains to be seen, I think.
Okay, yeah, please go ahead.
By the way, there's one other point if we're diving a little deeper into this. One thing that is a unique feature of the Trump administration is the belief that a number of firms, particularly ones like digital platforms, have engaged in, some could call it censorship or viewpoint discrimination of conservative voices, and believe that they've made announcements about the fact that they were looking for potential collusion. So an example that was cited by, I think it was the FTC chairman, not that a case has been brought, is this idea that during the time of COVID, there were websites or other speakers who would talk about COVID and whether you should wear masks or not. And those voices were critical of wearing masks. And the allegation is that a number of the platforms and maybe even news organizations censored those voices by not amplifying them. And this gets into a very touchy subject of whether that should be viewed as misinformation. At the time, I think people know of Anthony Fauci, who's like this chief virologist, saying, no, this is not good science. But nonetheless, there are statements being made by the Trump administration or officials in it that they are looking for potential cases. There were suits filed against organizations already. I think one of them just got thrown out on a motion to dismiss, basically at an early stage. But there are fascinating questions. This is obviously a sensitive topic because we have something called the First Amendment, which is basically that the government doesn't have a right to censor companies. And obviously, I don't think this is the classic antitrust, but it's certainly, I'll call it an interesting development.
Yeah, and I'd like to add to that a little bit, given what Michael mentioned. So for instance, I don't think they have to put into place regulations per se, just the threat of of being under the regulatory scanner might be enough. So for instance, if we look at the case of Meta, where again there was this concern that there are certain kinds of voices that are being amplified, and others are probably getting removed from the platform, even though Meta does not remove quite as much as it should, in my opinion. But regardless, Facebook went ahead and disbanded its entire team of fact checkers because they were more politically aligned to one side. And so I think for platforms to actually change their behavior, of course, laws are one thing, but it does not just have to be a law. It can also be just a threat of any kind of action which might make them change the way they operate.
Yeah, totally. I agree that that intersection between free speech, information, and platform competition is really interesting. But let me move forward to, I don't know, Carlos, if you want to say something about the Trump administration, or we just move to the next question.
I hope he doesn't come to Peru soon.
Okay, so before you said that somehow Latin America is not ready for adopting digital regulation because it's in a previous stage, right? So let me go deeper on that. And do you think that digital platforms in general, I know that you should distinguish between different cases, but in general, are they more like a challenger to the traditional incumbents in Latin America, small market or concentrator markets? Or do you think that we are, as, I don't know, in Peru or maybe in another country in Latin America, moving more to a tipping point stage on some digital platforms market?
Okay, as you might have guessed from my first reply, the underlining premise of the tipping point discourse, right? I'm really not very friendly with it, right? I really don't believe that winner takes all and network and theories of network effects are complete enough to understand what's really happening in these markets, right? When we talk about tipping points, for example, I think it's greatly exaggerated. I mean, the idea behind this is that we will reach a moment in which companies will become monopolies. And once they become monopolies, they'll be bad monopolies, and we won't be able to change that, right? So we have to stop them before they get there, the preemptive strike. I think it's largely exaggerated, right? The idea that there's only going to be one winner is an oversimplification of market dynamics, especially in the digital arena. I mean, I'm looking back at my childhood when there was nothing digital, and I remember my father buying 3 newspapers on Sunday, you know, just to do all the crossword puzzles and read all the news. I mean, he was multi-homing, and we do that every day. I mean, every one of you has 2 or 3 shopping apps. You have 2 or 3 cab rides. No, you don't? You have one? You're a loyal customer. I mean, we were kidding, but I mean, I have my Windows here, and I have my Android here, and I have my other iOS device, and we multi-home, and it's absolutely normal. It's not that we're going to inevitably go to one company. It's going to be a monopoly. We're never going to change, and the winner takes all thing also exaggerates that, you know, the winner will be permanent. And I'm old enough, very old enough, to remember companies that once were, you know, the unsurpassable giants. Kodak, it's a footnote in photography history, and Fuji, which was the little guy, is not only relevant in photography, but it's now a giant in cosmetics and in pharmaceuticals. Why? Because they innovate, right? Monopolies, achieving monopoly power, great market power, without continuing to innovate will lead inevitably to your fall. And we've seen this in the digital space thousands of times, right? I can remember MySpace. That was my first. Yeah, it's a joke, but yeah, I had a MySpace page, right? And I remember Palm Pilot, and who can forget BlackBerry? I mean, it happens, and it will continue to happen. Network effects don't necessarily guarantee that your monopoly is unbreakable. And again, innovation is key here. Companies that don't innovate will inevitably die. And then there's another issue that we always think about the benefits of achieving network effects, but there's always negative effects of achieving these large network effects. Ask anyone under 25 if they use Facebook, and 99% will say, ooh, right? And ask the same question to people under 16 if they use Instagram, and they'll say, ooh, because there is such a thing as, negative network effects. I mean, networks can reach a size and a popularity that actually turns people off, or you're invaded with more invasive policies or pop-up ads, and you abandon them. And people's preferences are constantly changing and evolving. So again, MySpace, BlackBerry, they died, right? So just the idea that consumers will be trapped with one monopoly and won't be able to switch, again, in the digital world, it's even a less solid premise. Switching costs in the digital world are very, very low. You get free apps all the time, and suddenly I can't keep up with all the new apps that are suddenly, the big trend, and how the old ones, my daughter looks at my phone and says, Dad, you're so 2010s. I'm like, yeah, I'm old-fashioned because I'm 2010s. So does that mean that Mercado Libres and Ubers and Didis and Nubank and all these large digital players in our economies shouldn't be investigated? No, they should be investigated. They should be thoroughly investigated like any company under our traditional ex-post monitoring rules. And if we eventually see a proven harm to competition, of course they should be sanctioned. But the idea that we should stop the monster before it becomes a monster, I think, again, is largely exaggerated.
I think that you make some really interesting points. Just as out of personal experience,
You had MySpace as well?
No, I was going to say that my employer. What I was going to say is I do think that large companies, for sure, are not above scrutiny, and that it's absolutely appropriate for competition authorities to ensure that there's a level playing field. I do think there's an interesting phenomenon, this is my own observation, which is that at the moment, a company's market share could seem so durable, or its power seems impossible to topple. And I'm thinking of the fact that competition often, it's creative destruction. And so I was at Intel, the chip maker, and Intel seemed insurmountable. In fact, so insurmountable that the very definition used against Microsoft in the cases against Microsoft was defined as an operating system based on an Intel processor. You're going to get sued when someone uses your company's name in a market definition. And Intel has fallen on hard times. I just read in the newspaper today that the government may make a bailout for them and take a share of the company. And the point of it is who's toppled them? NVIDIA, because it's GPUs. And that wasn't, yes, they were investigated for antitrust, but I would say the larger phenomenon is NVIDIA. And in the case of Google, I would say, we'll see if I'm where I am in a year, because we're facing what I would say the most serious challenge in the 14 years that I've been at Google, which is from AI and OpenAI and ChatGPT. And what does that do to search? I'm just curious, how many people use maybe once a day an AI search to find information? Okay, that's a decent, maybe almost half the room. And so the question is what will that impact be on search? Which is how Google has made its money. Now, you could say, and we'll see over time, whether it's a replacement, it's a complement, whether there's some overlap where there's some traffic that's lost, but other traffic is not impacted. But the point of it is that this is dynamic competition. It's not another search engine like Bing. It's coming from a totally different technology. And so just in my work experience, you know, you think you've been hired at a company and that'll be your, you know, your retirement from that company. But then along comes dynamic competition.
Yes, thank you. Thank you, Michael. Well, let me go now to abuse of dominant and monopolization specifically. So normally, competition law has, at least in Latin America or in continental law, not in the U.S., but normally you have somehow of a catalog of different conducts for abuse of dominant behavior, like, I don't know, tying, discrimination, predatory pricing, sabotage, etc. But somehow the cases on digital markets have raised the wrong concept as, I don't know, self-preferencing in general, or now ecosystem theory and leveraging. So my question for you, Carlos, at least in the Peruvian experience, how digital markets are challenging these traditional concepts that sometimes aren't in the law. Do you think that this is just a labeling issue that it doesn't matter, or it has a more substantive issue behind that?
Okay, I want to go back to what you were saying about dynamic competition. Competition is dynamic. It's constantly changing. Everything is constantly changing. So these challenges are not new for antitrust law. I mean, markets are dynamic. Commercial strategies are dynamic. Innovation is dynamic. Everything is permanently changing and evolving. And the way we do business now is completely different than the way we did business 20 years ago. And it's completely different than the way we did business in 1890 when the Sherman Act was enacted, right? So everything is different. We think of traditional typologies like bundling. Bundling wasn't around until 1950. It didn't exist during the first 60 years of antitrust law. And today, for us, it's absolutely traditional category. Again, because antitrust law evolves and adapts to the changes in market dynamics. Do we need to draft new laws and amend the laws and create new typologies? I really don't think so. And I think that antitrust law has done pretty well during the last 135 years, and it'll keep on surviving as long as it's flexible and adapts to these circumstances. The Peruvian law, from my experience, is pretty curious, because being a Roman-German civil law jurisdiction, right, our antitrust law is actually a very flexible, right? It's more American than it is traditional Roman-German civil law, because we actually allow for conductas efectos equivalentes, equivalent conducts, which is completely against the principles of defined sanctioning typologies in our system. And I think it's correct. I think that's the way. It's what gives our regime the ability to adapt and survive. I mean, when we talk about self-preferencing is bundling with refusal to deal. I mean, and we can finally sanction those conducts if we demonstrate, and there's an effective harm to competition, through the existing mechanisms. The same with ecosystem leveraging. Ecosystem leveraging is bundling and leveraging, two very traditional antitrust categories that we're all very familiar with, right? So I think that, at least, I don't know if all jurisdictions in Latin America have the flexibility the Peruvian legislation has, but I think we have a sufficiently solid legal regime to be able to adapt to whatever challenges digital markets bring.
Okay, so let's imagine that we have our digital market case with one of these conducts, and now we want to measure the impact of this digital conduct, and let's say it's a non-monetary conduct, so you don't have a monetary price for giving a service or a digital product. So let me go first with you, Michael. What do you think are the digital metrics that you think that is, I don't know, reasonable or feasible to apply, maybe in general or maybe thinking in a specific conduct in these affairs?
Sure. So let me answer it in two parts. First, I think we should get our sort of concept. So I think we're talking about self-preferencing here and what metrics might we use in a case like that. So I think, first of all, my starting point is I believe in the consumer welfare standard of looking at harm to consumers. That's my belief that that's what competition law, and that certainly it's the premise of US competition law. Have prices gone up? Has supply gone down? Has innovation gone down? And these are actual demonstrable events that one can measure. And so I think we should think about it in that way. I also think we should recognize, and I'll get to this, self-preferencing isn't recognized as a theory of harm in the United States. And the reason is that in some ways there's no limiting principle. What does it mean to self-preference? So for example, I think many economists would say vertical integration can be very advantageous. It can create efficiencies. I don't have to go to two places to get something. The company may have an efficiency that's based on it. No, I'm not saying it's always, but the point of it is vertical integration has to be judged on the individual facts. And so I think that vertical integration also could be seen as a form of self-preferencing. I'm not opening myself up to others. I'm not letting others necessarily inside. And so I think we need to keep that in mind. Now, having said that, I do think what's interesting is so like I mentioned, in US law, we don't have this concept of self-preferencing because of the fact that it's viewed kind of like discrimination. What does it mean to discriminate? How discriminatory? Now, I realize that the European Commission, and certainly this is at the heart of the Google shopping case, of this concept of it, but under US law, people have resorted to other theories, like a refusal to deal. I'm not sharing. Maybe there's a tie or a bundle. I'm making you take two things at the same time. That was the theory in the Google, in the cases against our app store, Google Play, that you're making me use your billing system in order to sell my apps. Now, I could argue, what's Walmart without a cash register? It's a digital cash register, but nonetheless. And then another one might be predatory product design, that I make seemingly product design choices that seem to have no meaningful consumer benefit. And so people have resorted to those. Now, getting to the specifics of the way you would measure it, and this is something I do for a living. So if I were going to look at something and I was going to say, is there self-preferencing? And is there harm? And taking it as a given that I have to deal with a self-preferencing law. I think one thing is you look at the practice, you look at, let's say, traffic patterns away from Google before the business practice began of the alleged self-preferencing. And then you look at it after. How much traffic might have been diverted? Where was it going before? Where was it going after? What were the click-through rates? Click-through meaning someone went somewhere and then they clicked down as opposed to just leaving it. One might also look at new entrants. Were there new entrants during the time? I had a case where there was an allegation that Google showing certain reviews had harmed a large website that's an app that's known for reviews. And the claim was that we were diverting traffic. And I showed that there were new entrants entering the market and growing at the same time. And as a result, the European Commission didn't pursue that. But the point of it is looking at evidence of new entry, because you would expect there would be no new entrants if you've really chilled the market. You're deterring entry. Another example of something that you could do, which I think is really powerful, are doing surveys. Where did consumers go? Where do businesses get their traffic? And asking them for information. Now, again, I think all of this is in service of the consumer welfare standard of showing that there's been actual exclusion or foreclosure. So I don't think analytically it's different, but those are the techniques I would use for a digital platform.
Yeah, that's quite interesting. of course, you speak from a exclusionary abuses theory, right? But at least in Latin American countries and also in the European Union, you also have this exploitative abuse theory. And for instance, let's mention the Apple case at the European Union that was decided last year, where the commissions, among other things, said that somehow the policies that Apple was applying to the iOS service or the App Store, and particularly regarding anti-steering provisions, said that they somehow produce it or reduce it the quality of the service of the app, and also reduce it the freedom of choice of consumers. So there you have another theory of harm that is non-monetary and somehow it could be difficult to grasp in certain metrics. So I just want to provide that as context for asking you, Mimantha, what do you think about these matters? Whether exclusionary, as Michael referred in self-preferencing cases, or more exploitative ones as Apple decision.
I mean, the way I think about self-preferencing, and more generally economists think about self-preferencing, is, of course, in theory, consumers have all the choice in the world to choose among a whole basket of options as to what they want to consume. In practice, we do know for a fact that consumers face a switching cost. There is a lot of consumer inertia. I probably am going to start using option A if I see it often enough, and then not going to search for option B, even though potentially, we don't know, option B might just be as well as option A at some point of time, right? And so self-preferencing is, in some way, given the platform has power, say in terms of its market share, now is the platform able to present its products to consumers so that they are more likely to choose those products or services. And partly, I believe, just sticking with this idea of market shares or profit margins when we think about harm caused by self-preferencing might actually be a bit more limiting, because it's not that, while in practice, in theory, it sounds easy to show that prices rise or do not. In practice, it's extremely difficult because the counterfactual is not available to you. What would have happened had this policy not been implemented? Now, as much as people tend to rely on survey data, we do know the problems associated with survey data. Time and again, we know for a fact that what consumers state they want to do or what they like is inherently very different from what they end up doing when it comes to consumer behavior. So when I think about metrics that I would ideally want looked at when it comes to self-preferencing, like Michael said, of course, I would want to start with something as simple as impressions, right? When consumers are looking at a specific page of information, are they more likely to actually come across products or services in which the platform itself has a stake? For instance, on Amazon, that would be Amazon basic products, right? Another thing could be, we have a very rich stream of research in economics which has documented very robustly rankings matter, right? How many of you, let me ask you, do all of us use Google search to a large extent? Show of hands? Yes. So how many of you actually tend to go on the second page of Google search? Depends, but I see a few in not very sure hands, right? So we know for a fact that rankings matter. Even if let's assume Google's algorithm is great, but even if it weren't, if there are closely related options that might be relevant to your search query, if it's on second page, you can basically wish this idea goodbye that people are actually going to reach that page or get exposed to it or consume the information on that page. Similar is the case with ranking of basically everything across digital platforms. And rankings matter. It matters because consumers consume more of what is ranked highly. So one thing that would be important to look at is, are platforms' own products or services being actually given more of a bump in rankings relative to the competing products or third-party products? Because rankings basically are dictated by algorithms. I think I'm obviously not in favor of digital platforms disclosing the way their algorithm works. That probably first is not prudent, and it's not going to lead to anything good, but it might help to understand what they're weighting, what are the factors that they actually weight. Because it won't be impossible to believe that certain factors, say the brand of the product, which might be completely unrelated to the consumer search query, are also being weighted in the algorithm. It's, yeah. There has been some research which actually, pretty much a working paper at this point of time, which actually shows that once certain kinds of products actually become very popular on Amazon, using Amazon sales track as a proxy for popularity, Amazon is more likely to enter that market and start producing those products as Amazon Basic as well. And so these platforms have access to certain kinds of information, which is where interoperability also comes into place in addition to self-referencing. But the problem is other merchants who are operating on these platforms really don't have access to the same kind of data that these platforms have. And so the question is, of course, there's potential for these platforms to actually use this data by foreclosing other competing merchants on the platform by having access to the data, which is where API restraints come into the picture. So in some way, of course, all in the bounds of privacy, there are certain kinds of metrics that should be available to competing merchants as well, which allows them to compete better in the market. And another thing to look at, the metric to look at there could be in terms of APIs, whether API access is being given to a large proportion of data sets. What is the API rate limit? What are the proportion of errors thrown by the APIs for third-party API calls versus internal calls? And what is in some way the time it takes to download a specific amount of data through those API calls for a third party relative to an internal call? That could be one other thing. And I think one thing which we haven't really touched upon, but it also deals with, it deals with, again, self-preferencing, is this reliance on default options, right? On a lot of platforms, you have some defaults, and more often than not, consumers go with the default option. We don't tend to change that. And I think it would be important to understand platforms conduct all kinds of A/B tests. On Amazon, and I guess also on Google, you have hundreds of A/B tests being conducted every day. And so the question is, if these platforms weren't using their own products and services as the default option, then what is the share of revenue that comes to them or their products relative to competing products? And of course, I can go on about metrics, but that's not the point.
No, yeah, thank you. I think that is a big challenge for us as lawyers to get more understanding of these digital metrics of traffic ratio and AP calls, for instance. So yes, we don't. It's not economical, but it's more computational, and that is something that we should grasp anyway. Michael,
I was just going to add. So I think you raise very interesting questions, and at the heart of the question of defaults or ranking is the question of maybe is there stickiness. And I think it's a fascinating question. I wouldn't disagree that having a default can have an effect. The question is how much? And so a really interesting question, for example, is if you got a new phone, and let's say, for example, that new phone has services made by the operating system, a search engine, a browser, a dialer, which you may, the phone who you're using, maps, email. Does anyone want to start up their phone and spend the time going through each and every service, picking it? Now, you could say that's the user's choice, and so you should. And this is, I think, a really interesting question. But I do think, you know, I wouldn't dispute that rankings affect things. I mean, one argument is that the ranking is correct or largely correct, which is why it is that people don't go to page 2. They got what they wanted. But that's not to say that, again, that platform companies, and I'm not speaking for any or all of them, shouldn't be scrutinized for any competitive conduct. I just think it's a fascinating question about behavioral economics and human behavior as to how much it is. I mean, we go into a supermarket and things are paid by often the manufacturer to put it at eye level, and other things are low, and you may never even notice it. Now granted, you could argue that your local supermarket doesn't have market power. But I do think it's the same sort of practice, but in a digital era. And so it's not fundamentally that different. Now you could say what's different is the market share, but I do think the human behavior aspect of how much is this influencing or novel, I think is an interesting one.
Yeah, actually, I want to ask a few questions about behavioral economics, but before that, Michael, there's always this trade-off or tension between innovation and digital regulation or digital enforcement. And I want to ask you about intellectual property rights, because normally digital platforms or tech companies, their main assets are intangibles or protectable by IP rights, as, I don't know, source code, databases, trade secrets, etc. So do you think that, or how do you see these mandates of interoperability or compatibility between platforms or digital products in their connection with IP rights?
So it's a really interesting question. I mean, the IP rights may or may not be at the heart of the issue. So for example, IP rights may play a large role, or they may be that it's the data, or it's simply the number of users that are really what gives a platform value. But taking the point about IP, I think one of the challenges is that there's a fine balance that most countries have struck about how to treat, say, patents. We have disclosure of the patent when the patent issues, and we have a limited duration of the patent, at which point it becomes sort of committed to the public domain. Yeah. And so we have struck this balance that we do give exclusion, that the patent owner can exclude others from, infringing on their patents, and at the same time, there's this duration. So we have a balance. So when we get into issues about, mandatory sharing of technology that is patented, I think we need to exercise care. I'm not saying that there's a blanket protection for patent owners and that there can't be patent, misuse in the sense of misusing their patents in a way to extend their monopoly beyond the patents themselves. And I think that's important, that they're using some of their business practice to get greater value than the patents themselves confer. And we've seen cases disputing whether that's happened. There was a famous case. It turned out that the FTC, Federal Trade Commission in the US, lost. They went after Qualcomm about that. But I do think that we do need to be careful about upsetting the balance, and that if we're going to do it, we really need to identify what is the harm and that we're limiting it. The only other thing, I guess two other things, maybe one other thing I would say is, when you have, say, mandatory licensing of IP as the remedy, you do have the authority becoming sort of a rate regulator. I don't think most authorities will say, well, you have to give away your IP for free. They'll say you can charge a rate for it, but you do have to share it if someone wants a license. And that puts the authority or a court into this awkward position of, how do they set the rate? What should the rate be? What should the terms be? How are they going to oversee this? And so it does intertwine the authority in sort of running, a complex business. That's not to say it doesn't happen and it's inappropriate in all instances, but I think one needs to exercise care before we just simply run into it, given like what I've said is the delicate balance that's struck about, ensuring that there are incentives to innovate as well as, the limited duration of the patents.
Yeah, sorry, I'm just curious, but would you do the same analysis for copyright law? Because, we know that patent law have certain amounts of time, but copyright is different.
Copyright, I think, is a really interesting one, because copyright doesn't protect ideas. Copyright, for those who are not up on the differences, I mean, a patent normally we think of as a patent protecting an invention, say like a new drug, or a new product design, to use the American expression, building a better mousetrap. Copyright protects the expression. So, examples of copyrights would be motion pictures or a book. And some people will say the copyright is thinner. The value is thinner because the contribution to the product is thinner. So for example, you can copyright a phone book or a map. You don't get protection for the names and numbers in the phone book or for the names on the map, but for the color and the design and sort of the style of it. And so when people try to use copyright to protect, say, source code, I think one has to look at it carefully. That's not to say that they don't have a valid copyright and there can be infringement, but I think of patents as a stronger sort of argument. I mean, Apple has used copyright to protect certain aspects of the iPhone in cases that have sought to open it up. But I would say in general, if I had a choice, I would rather resort to patents than copyright.
Yeah, interesting. Yeah, I understand. Before going with you, Carlos, again, let me ask you, Mimamsa, because you mentioned before something about default options and behavioral economics. And what is your opinion regarding this vision of the rational consumer, the neoclassical vision that have certain amount of information and can freely choose the products or services that he or she wants? What is your insight from that? And are you aware of experimental studies that somehow, with the current digital platforms, challenge that paradigm?
Yeah. So yes, I mean, I come from classical economics training, where we like to believe consumers are rational. And indeed, a lot of assumptions we make about how people will behave, our predictions about how they will behave, traditionally have rested on this assumption that people are welfare maximizing. They will choose the option that maximizing something's value to them. Now, there has been a lot of research which documents that consumers have what we call bounded rationality. We are rational, but only to a certain extent, which is not surprising, to be honest. It makes sense. And particularly in case of digital platforms, there have been cases where the worry has been that platforms deploy certain kinds of design tactics or user interface design, which actually have the intention of choosing consumers, making consumers choose those options or taking those decisions which are not in their best interest. So in some way, making consumers take some harmful actions or not optimizing. And my personal view is that I don't think we can think of consumers as being fully rational or being fully irrational. The truth lies somewhere in the middle. In fact, I think recently we do need to update the way we think about consumers according to these lines. We need to think about the fact that consumers do behave in an irrational manner at times. So for instance, we talked about the default option. There has been a lot of work which consistently shows that consumers are more likely to choose the default option regardless of how good that default option is or not. And I think when we talk about, these are what is referred to as dark patterns in some cases as well, right? I don't particularly like that word, the term, but I think before making a case about whether platforms are indulging in these activities and are they actually benefiting themselves at the cost of consumers, obviously as economists we are always asked to quantify this harm, right? And I think there are ways of actually doing this. I come from the paradigm of field experiments. I do A/B tests with platforms, and I think one way of actually looking at it is through A/B tests. That said, so yeah, I think long story short, we do need to update how we think about consumers, and certainly consumers do not always behave in a rational way, but I think at least economists to a large extent have started to account for that, and in no way, and it doesn't hurt the fact that over the past decade, 2 behavioral economists have won Nobel Prizes. So of course, we are more open-minded towards that aspect of consumer behavior.
Okay, thank you so much. Carlos, let me go back to Peru again, and there is a discussion, at least there is in Chile, I don't know, in Peru, about this idea or figure of economic dependence that has some relevance for relations or vertical relations between a big company and a smaller company, and somehow you can see that as well in the relation between sellers and marketplaces or digital platforms. So before going to the digital part of the question, what is the status of this this typology of economic dependence in Peru? Does it exist?
Non-existent.
Okay. Well, what is your opinion on that figure or the relative market power?
Okay.
Control.
I hadn't thought about this until you asked it, to be honest.
Perfect.
But I kind of figured it out. But
Let's improve.
to your point, I mean, when a web page is designed for you to make that irrational, emotional decision, right? That's what marketing has been doing for the last 100 years. I mean, when you go to the supermarket and that overpriced chocolate bar is right at the eye level of my daughter.
Absolutely, that's
you know,
impulse consumption.
yeah.
Of course, yeah.
So I mean, I think we're analyzing the same phenomena just in a different context. I mean, but I totally get it, and it's behavioral economics is and Williams and about the rationality and everything is very fun. But as a lawyer, sometimes it's a little more difficult to understand why we're making such a big fuss over the same issues.
I mean, just to respond to that, we do that a lot, to be honest. So how many of you have actually, you know what, let me take a guess. I think many of you have been stuck with this idea of when you subscribe to a subscription service, every month, like clockwork, by default, that amount gets deducted from your credit card. Does it happen to all of us? How many of you has it happened that perhaps you don't need that service anymore, but you just forgot to cancel it? Show of hands. There we go. This is what is again called, if you were rational consumers, and I tend to think of myself as being more rational and less emotional, but this happens to me all the time. So believe me when I say it, when I look at my credit card bill every month, I don't do it every month, but every few months, I have a whole list of charges that I don't know where they came from. And then that's the day I spend canceling all the subscriptions that I've erroneously subscribed to. And this is a classic dark pattern that's being used by platforms across the world. And insofar as my opinion is concerned, this is a regulatory failure, right? Consumers no longer need this product. They have an inertia. They forgot to cancel the subscription. And like clockwork, you're still paying for the product you no longer need, right? And there has been research which actually documents this. By randomizing consumers, they do tend to find that in case of recurring subscription fees, consumers actually tend to overconsume the product. They tend to pay for the product that they no longer use. And so, yes, I mean, this works in practice.
I mean, my gym wouldn't exist if it wasn't for that, right? So, well, anyway, going back to your question.
Yeah.
Is it typified? Does it exist in Peruvian legislation? No, it doesn't. Should it exist? The way you phrased the question, right? Should we, for instance, could a claim be raised by a small company regarding its relation to the owner of the marketplace, whether or not a high commission or an anti-steering clause is in place that limits its power? And that brought me back to reminded me of something I heard I learned, I guess, from a law school professor at Yale, right, who recently passed away. And he said there's no room at the antitrust table for small business. And I remember when he said that, and we were discussing some sort of bowling alley case, and what he was trying to say was, I mean, antitrust should only concern itself with consumer welfare, not how the mom and pop store, how the small business is going about. He was very, very radical. But I'm not saying that these types of concerns are completely oblivious to antitrust law. In the Peruvian case, at least, the whole exploitative abuse thing, you know, and I think most everyone knows here, doesn't exist in Peru. We pretty much abolished that over a decade ago. So exploitative abuses, there's no way the Peruvian antitrust authority could see it. Eventually, an anti-steering of a small business, so long as it was exclusionary, had some sort of exclusionary effect, obviously would fall under the umbrella of legislation and could be analyzed, but always with the bar that it has to be a dominant firm, right? When you pose a question, well, in this regulation that implies lowering the standard away from dominance and maybe adopting some sort of European significant power test, right? Could that be seen under unfair competition law? Yeah. And I think that's extremely dangerous, because then you open a back window for things that we don't want to mess around with. I mean, every time antitrust law is applied to a dominant firm, we're limiting we're limiting its liberties, its freedoms, right? That's what it is. It's state intervention to limit individual, in this case, companies, freedom to act, commercial freedom, entrepreneurship freedom, or whatever you want to call it. And that's very restrictive, right? When we lower the standard away from dominance and we say, well, anyone with some sort of significant market power can be judged, but through this other set of laws, then we open the floodgates, and then the standard is significantly lower, and the space for government intervention or authority intervention is much greater. And I think that's that in itself is very risky. So I think that so long as, if it's exclusionary and it's dominance, there's always going to be a space for at least Peruvian antitrust law to see this. Should we open, back doors to see this through other legislation? I'm not really a big fan of the idea.
Okay, thank you, Carlos. And finally, what is their experience of Indecopy, in your opinion, with enforcement of digital cases in abuse of dominant or unilateral conducts?
Again, very limited. Indecopy's basically limited itself to market studies lately. Anything that's we've had at least 2 or 3 different what we call market studies. That's what we call it. I mean, which is basically what is the state of competition in this type of market, right? So we've seen credit cards, and we've seen digital payment platforms. There's one ongoing on delivery platforms, right? But it's very cautious. It's just, I'm here. I think it's saying, I'm here. I'm aware of these issues, but I'm just studying them right now. And I think they're being very cautious, and I think it's correct. I mean, they're not diving headfirst into the deep waters yet.
Okay, thank you. I had more questions, but because of the time, I cannot make it. But if you want to close with like 30 seconds to say something else, Michael and Mimasa, that's okay. So yeah, 30 seconds, 40 maybe.
I have a comment, which I think is, relates to digital platforms. Like I said, and I'll repeat it again, it's not to say that digital platforms are somehow above scrutiny. And in fact, I believe very much in proper antitrust enforcement. I do think an interesting thing is this, though. People talk about digital platforms. And an interesting thing that we look at is normally we assume that when a company gets very large and has high market share or perceived high market share, that it will stop investing, and that it doesn't face incumbents, it doesn't face the risk of entry, of new entrants. And I think one of the things, and I just did this yesterday, I looked at for 2024, what did Alphabet, Amazon, Meta, and Microsoft spend in R&D? And I think it's an interesting thing because it gets to the question of, how do we think about these firms? If they have high market share, again, one wouldn't normally expect them to be investing the way they are. I'm just trying to find it real quick. I know this is not 30 seconds. I have a lot of pages here. But, okay, here I got it now. Okay, so for this is, and you can look this up. So for R&D, Alphabet spent about $50 billion in 2024. Amazon spent $88.5 billion. I should point out, and this is the best I could do, that they spent probably nearly $20 billion of that was actually Amazon Prime, which is TV and movie content. One question whether that's R&D, but so let's say it's 68 billion. Meta spent 43.9 billion, and Microsoft spent 29.5 billion. Meanwhile, on capital expenditures for AI, Alphabet announced it's going to spend 85 billion this year, Amazon 100 billion, Meta 72 billion, and Microsoft 80 billion. Now, one might not expect, and again, you know, spending on R&D, there's a lot of caveats to that. Is it relative to the revenue? Is that the right ratio? I think by almost all measures, this is high. It's higher than pharma, which is known for being heavy spending on R&D. And so I think it gets to a really interesting question, which is, you know, what would explain the high spending? One argument is that the market definitions are wrong. Another argument is that there's a lot of dynamic competition or perceived dynamic competition, that these companies that are supposedly in other lanes are going to come into their lane, or other new entrants. And so I think it's just a fascinating point to leave people with, which is to say, obviously I come at it from the tech company's perspective that we live with regulation and scrutiny, and that's to be expected. But I would just say I would urge people to exercise a degree of, you know, care before jumping into the market and making major changes to understand these kind of phenomena.
Thank you, Michael. Mimantha, final remark?
Yes, so quick final remark in the interest of time. I think broadly when we look at digital platforms for decades, we've allowed them to operate almost with minimum amount of regulations. I'm not saying that we should impose onerous regulations on them, but just because they are spending a lot on innovation, R&D, does not mean that every practice that they undertake is also correct. We need to disentangle those two. Where it's justified, I think these platforms should face regulations, and authorities have to look into the fact that there might be certain practices that they actually do undertake, which perhaps in the immediate term might not be that harmful, but in the medium to long term, which is very difficult to quantify, might actually be very harmful. So I would actually urge the authorities to take more of a balanced perspective insofar as regulations for these platforms are concerned, because a lot of individuals, a lot of third-party merchants rely on these platforms also for their own livelihood. That's what.
Thank you so much, Mimantha. So thank you all three, and let's provide an applause to the panel. Thank you for coming, and we have only 10 minutes for a break, and then we get here again for the final panel of mergers. Thank you.